Amanda Mae Mason, is that correct?
Yes.
I'm having trouble hearing Ms. Novosel.
Yes, that's correct.
Thank you. Today's April 14, 2025. We're here for an arraignment. That file's 25P 02630FY. Ms. Novosel, your appearance, please.
Lisa Novosel with the Public Defender's Office, here today with Ms. Mason for purposes of arraignment. Excuse me, it does appear that she will qualify for public defender to be appointed going forward in this matter. We have had the opportunity to review the one-count felony murder complaint. At this time, we would waive formal reading of that charge. We've also gone over the advice of rights form, which she signed earlier today. We're waiving a formal reading of that form as well, and we're asking that the court stand and read to the charge.
Thank you, Ms. Novosel. Ms. Mason, just to clarify, Ms. Novosel advised she's gone over the complaint, the charge, the nature of the charge, and the maximum sentence. You are aware that you're facing one count felony murder, carries with it life without parole, DNA to be taken upon arrest. Do you understand that charge?
Yes, I understand.
Any questions about that charge? Obviously, it's just a charge. That's all it is at this point. Do you have any questions?
Not at this.
All right, thank you. She also indicates that she's gone over your advice to rights. Do you have any questions about your advice to rights?
No, Your Honor.
Thank you. For today's arraignment purposes, we're going to stand you mute, enter not guilty plea on your behalf. A probable cause conference is going to be scheduled Tuesday, April 22nd, 2025 at 9 a.m. in front of Judge John Monahan here in the Port Huron District Court. Also in front of Judge Monahan will be a preliminary exam for Tuesday, April 29th, 2025 at 10 a.m. I do have a pretrial service release recommendation. Advises the defendant is 33 years old, resides at the Henry Street address in Port Huron with her boyfriend and children for the past 9 months, has lived in St. Clair County most of her life. She's unemployed, last worked a year ago at, is a U.S. Fair thing. She denies any
Yes, Your Honor.
any mental health diagnosis. Defendant indicates that she does not use any drugs or alcohol, has no prior convictions. It's recommended that no bond be ordered with conditions she not use, consume, or possess marijuana, alcohol, or illegal controlled substances, have no contact with the co-defendant Maurice Houle, or any person under the age of 18. Ms. Novosel, comments regarding bond?
Your Honor, regarding bond, I would indicate to the court that my client does have ties here in St. Clair County, including in the form of family and children that she has here. She also has no prior criminal history. I understand the recommendation here is for no bond, and we understand that that's fully within the court's discretion. We would just ask that the court would take into consideration the fact that she has no other criminal history, and she does have children here in this community, so we don't believe that she would be likely to flee. Other than that, Your Honor, please bond up to the court.
Thank you. Mr. Sparley.
Judge, thank you. Judge Sparling on behalf of the people. Likewise, for the co-defendant, we would ask pursuant to Rule MCR 6.106 under Subrule B that this defendant be held in custody with no bond. While she does have ties to the community, for family and small children, we would ask that those bond conditions to be imposed, limiting or removing any contact with those minor children to make sure that they're safe moving forward. The only thing we know at this point in which we can state is that the children are not safe with her. These allegations stem from Matthew Mason, the same as the co-defendant. She had years of covering up for abuse. That was done by both Maurice Houle as well as herself. She admitted to us during those prosecutorial subpoenas that Maurice Houle was extremely cruel and abusive, that Matthew was locked in his bedroom for a long periods of time. She also admitted to investigators that she herself was one of the people that would take Matthew's head and had shoved it into the drywall, actually forceful enough to remove the backing off the drywall itself. She admitted that she had observed Maurice at previous times hold a pillow over the child's face, and we're talking about a 3-year-old child here. She admitted to lying about the abuse. She admitted to lying about what she originally told police officers, and as well she admitted to me that at one point she actually did not take her son to the doctor's appointment because of injuries he had, and she was worried about CPS involvement. She lied to CPS and investigators at prior times involving prior abuse of Matthew, and she admitted that as well. So the only thing we have that we do know is that she's a documented liar. She abused her son, and for those reasons, and the fact that she assisted in the death of Matthew, we'd ask for that no contact, or not no contact, certainly all those conditions, but that no bond be issued in this particular case.
Thank you, Mr. Starling. Ms. Mason, should you be released at any time during this case on bond, you're not to leave the state of Michigan without the court's permission, nor commit any criminal acts while out on bond, and you must appear at all hearings. In order that you not possess or use any weapons, firearms, or ammunition until further order of the court, that you have no contact with the co-defendant Maurice Houle or any person under the age of 18. Understand any violation of the no contact order could result in you being arrested and held without a warrant. That you could be arrested just for violating that order, and then you could be held for the remainder of this case. Understand no contact means exactly that, no contact by phone, social media, or through a third party. Do you understand that, ma'am?
Yes, I understand.
The court does take into account the factors listed in the court rule. Your ties to the community, I do know your lack of convictions on your record. However, this court also takes into consideration the allegations made that have been stated on the record that are contained in the affidavit of probable cause. I am looking at a one-count life felony homicide, felony murder of a 3-year-old child. The court takes that very serious allegation at this time. Therefore, under the court rule of MCR 6.106, this court will deny bond at this time.
Thank you.
Anything else, Ms. Novosel?
No, Your Honor, thank you.
Thank you.
Burn, bitch, burn.